20 years.
State Senator Bill Perkins. What do you think about today's hearing?
It looks like Columbia's going to lose.
Looks like why are you confident?
It looks like the judges seem to understand the problem, the injustice of the manner in which the blight was determined.
So you are optimistic about this case?
I've always been optimistic.
Do you think it has?
I'm even more optimistic now.
Do you think it has ramifications for the state and other cases that are pursuing?
I think it has a national implication.
National implications.
Yeah, especially since Keno was used as part of the argument.
Yes, Kelo versus the state of New London. Anything else you want to say in terms of the development of Harlem?
My name is Nick Sprayregen. I head our company, Tuck It Away Self-Storage. We're the lead plaintiff in this case against the ESTC and Columbia. And after this hearing, we're very cautiously optimistic. The justices obviously read papers and had a lot of very, very good questions, and I think that they get it, that this is an abuse of the Constitution and that this needs to be stopped. So hopefully we'll get a very positive verdict in a few months. I started working with Norman Siegel about 5 years ago, and it has been very long, very draining, both emotionally, physically, financially. But I believe that what we're doing is the right thing, not just for our family, not just for the people of Harlem, but also for citizens all across the state, if not the country, who are fighting similar abuses. And if we can make a difference here, it will send a signal to other institutions and other governments that they can't just trample people's constitutional rights.
Columbia doing wrong way. It is very racist. We are over there on 25 years. We're doing very work hard. So I know let them go like that. Columbia do wrong way to amendment. So I believe to God today we appear on the Appellate division. The judges listen to my argue. So hopefully I pray to God so they give decision on our favor, because that is the true story.
Today was a very interesting argument, and I hope the outcome of this argument will be in the favor of us, because what Columbia is doing is very bad and it's not humane at all. And it's not like it's a public university where all the people of Harlem or wherever else could attend. It's a prestigious school and only a select few will be able to attend it. So it's not for the public use at all.
Tell us about Floridita, your business, and why you're here today.
Floridita's been a family-owned business for 33 years. We've been established in West Harlem since 1969. I'm here in support of Sprayregen and Singh. Columbia owns the property where I'm in already. They're my landlord. They have, through the use of eminent domain, the possibility of condemning their own building and throwing me out if they'd like, even though I have a valid lease. But primarily I'm here with my 4 children to show them what this process is like, and it's been fair, it's been positive. You know, I don't want them to grow up in the United States where they have to worry about buying a property or getting into a lease and it not being honored or getting thrown out of their houses because a big, powerful, rich organization wants to throw them out. So hopefully, it looks like the courts went that way. It looks like the judges chose to go with the people and with the right. I hope they learned an historic lesson.
Anytime I see the use of eminent domain potentially expanded, it makes my blood boil, because I think that it's already a tool for the special interests and the corporate elite to gang up on the little guy, on the small entrepreneurs that make our country sort of equal and sort of special. I'm doing whatever small thing I can as a student to show that even though I'm a student at Columbia University doesn't mean that I endorse everything that they do.
The attempt for Columbia was to sort of ignore the community and put all of the governmental forces in conjunction with each other to get this through, and the fact that the community was so consistently opposing it, I think broke through that facade.
Right here to record this historic moment, why were there numerous references to the Kelo versus New London Supreme Court decision, and what's the relevancy of that to this hearing today?
Kelo is a sea change in the whole way that courts will look at eminent domain. We've been saying that for years. Very few people believed us. They thought it was rhetoric. The questioning today by the court shows that it's not rhetoric, it's real. And Kelo is very important because Kelo basically said, perhaps we're going too far on eminent domain. We need to make sure that when the government comes up with arguments as to why they want to use eminent domain, that it's not pretextual, it's not favoritism, it's not giving a developer the land so that the developer can develop, and you have to have a carefully considered plan. And Justice Catterson got it absolutely right. This is the opposite of Kelo, because in Kelo, the New London City Council had a hearing on what to do with the land before they determined who would develop it. Here, it's just the opposite. It was always, starting in 2002, all about giving the land to Columbia. And we've been saying that for 5 years. Very few people listen. Hopefully, thank God, the court seemed to be listening, and hopefully the court will write a decision that will say no to eminent domain. And lastly, it's a team effort. Us lawyers couldn't do it without this guy, with you, and the people that are here. And what's great about that is that's what democracy should be all about.